master class is to develop that interest in you all. Okay. So we have specifically curated this masterclass sessions, which will be around 5 to 6 sessions taken by the various faculties from Kelly Law College. Okay. So we have specifically curated such topics which is nothing but a hack into the subject. Okay. So once the confirmation for the screening is given by the team, then we will begin with the topic of discussion today. Okay. To recite the agenda, I'll just quickly mention how the flow will go on. The first session, which is today, I will be taking that. The agenda will be the basic concepts of jurisprudence, building a foundation of the jurisprudence in your mind. The second session will be taken by Aditya sir. That will be scheduled for tomorrow, and he is going to take on rights, liabilities, ownership. And third session will be taken by Tanmay sir. He will be taking the schools of jurisprudence with you guys. Fourth session with Manoj sir. He will be taking sources of law. And fifth session with Subhash sir, the uses of jurisprudence. Okay. So this is an overview of our master class, how it is going to be scheduled in coming days. Okay. If you find any difficulty, please reach our coordinators and please register your query and we will get back to you. As you know, this is a certificate course, but certificate course has its requisites. First is the attendance. You should compulsorily attend all the sessions. Very first requisite. The second is there will be a exam in the end. We have scheduled a very easy MCQ based exam, or we are planning on that, but on 15th we will 15th or 16th we will have that exam. So following that, the certification will be given to the successful participant. Okay. सब्र का फल मीठा होता है. So just have some patience. Once we start, I hope you will enjoy this journey of masterclass on jurisprudence. I know many of you are watching time on your watch, on the clock, on your phone, but get a hold. We will try our best to finish it before 4 o'clock.
It's a good thing to note that so many people are gathered here, and still a lot of people in that group. Really, it is encouraging. And I don't know what motivates you to get connected with the jurisprudence, because jurisprudence generally is not a very dry subject, okay, and it is almost all called it is a non-utilitarian subject, doesn't have any application also. But this is something contrast I'm seeing here. It's a good thing that you have taken interest in jurisprudence. And jurisprudence is nothing but a skill you have to develop on your own. Jurisprudence is something connects law with the facts. Okay, it connects with the fact. It tries to analyze the fact. Okay, and how the fact influences the law, or how the law influences on the facts. So it interacts between these two things. The relation between the fact and the law. Sometimes fact influences the law, and sometimes law influences the facts. And if you understand these three things, then you will be master in your professions. And without knowing these things, simply studying a law is a waste. Okay. Just I'll give one example. You can think what would be the purpose of jurisprudence. Example, along with your friends, you went in the forest. to enjoy something. And all of a sudden you notice that there is one skeleton lying there. Skeleton. Okay. And it was lying there in the forest for a long period, because if you see the skeleton, you could have imagined the only thing it would have been dead long back. And that skeleton was having some golden diamond ring in the finger. And all of a sudden you notice the curiosity and you remove that golden ring and you took it because no one was there. Okay. Then what happened thereafter? You came back to your house. Then there was a missing complaint against that fellow filed in the 2 years back. Missing complaint against that fellow. Then ultimately the police succeeded in knowing that this is the same person against whom the missing complaint is filed. Then the relatives came, they recovered the body and they gave a decent burial. And they remembered that fellow was carrying some golden ring in his ring. And those fellow filed a complaint about missing a golden ring. So the question is that what is your liability? Decide it. What is your liability? In what, in which law comes, in which provision comes, whether it comes in the IPC, whether it comes in the CPC, I mean civil court or tort, contract, find out. And answer your question. I mean answer to that question with your own reasons. Here no definite reasons are there. Everyone comes with their own reasons. Apply your mind, apply your reason, apply the fact, apply the law, and try to find out the solution. Okay, and these are things you won't get in the books. These things you won't get in the books, you won't get in the Contract Act, you won't get in the IPC, you won't get in the Constitution, you won't get it. So here the question comes, your relevance of jurisprudence. It tries to help you in what way you can solve this problem. And that is what you have to learn. And if this is a skill you do not learn it, then what will happen in your career? Okay, because always the law is all about a speculative. Law is always ambiguous. Law is always abstract. Okay, law is be never certain. Law is never as precise. It is always ambiguous. So that ambiguity has to be settled, and that settlement of ambiguity lies in your skill. Okay, and that skill you have to acquire it. And that skill you will acquire it only if you have a reasoning capacity. And that reasoning capacity you will get only in the jurisprudence. How to reason it, how to find out it, how to relate it. That's what the purpose of a jurisprudence. Okay, and if you are good in the jurisprudence, obviously you will be good in a lawyers. And if you are not in good jurisprudence and you are good in the constitution, you are good in the contract, you are good in the IPC, it doesn't make any sense. I am telling you. Okay, so you ought to be good in the jurisprudence. And jurisprudence is nothing but common sense. Jurisprudence is nothing but common sense. And what is the source of a common sense? What is the source of a common sense? How you acquire common sense? What are the means of acquiring the common sense? And do you have common sense? Answer it. Do you have common sense? Common sense you get it by reading? Or common sense only educated people will have? Even uneducated people have more common sense than you? Or educated people will have more common sense than the uneducated people? Difficult to answer. And the common sense, how you acquire it, what are the source of a common sense, that's all about the jurisprudence. Understood? And you think that you can acquire common sense by book, then you are under fool's paradise. If you are under the impression that I will acquire common sense only by reading books and scoring 90%, 80%, getting the gold rank, you are in the fool's paradise. Understand? And you are not acquired the common sense. You are acquired only books knowledge, but not a common sense. Common sense you acquire by three things. One by experience, one by experience, one by knowledge, another by observation. You got the point? So one experience you must have. Second, knowledge. Read. Go on reading it. Everything, anything. That is second, you get something out of it, and you get something out of an experience, and then you get something out of an observation. Always observe. You learn more from eyes than hearing. Okay, keep observing, keep go on observing, watching it. Simply watch it. You will learn so many lessons. You will learn so many things. So combination of these three things: experience, knowledge, observation, makes your reasoning capacity more strong, and that blend with your profession, definitely your profession, and you will earn like anything. You will earn like anything. And if you do not know these three things and you know all 395 articles of the Constitution, verbatically you can reproduce it, it doesn't make any use. Understand? So this is what is the purpose of the jurisprudence. So learn the law with the experience, learn the law with the knowledge, learn the law with the observation. Then that takes you somewhere. Then you can be a good lawyer. If you go and watch the practicing in High Court or Supreme Court, now you are available, accessible. How they watch, how they observe, how they argue it. They less argue on the provisions, they more argue on the social facts. What is the point? Their argument is less on the provisions, less on the law, but more on the social facts, and they connect with the law. Okay, you acquire the facts, acquire the facts. And fact can be acquired only through a society, only through a political, only through economics, only through industry, only through philosophy, only through science. And if you have the knowledge of all those things, then you will have some knowledge about jurisprudence, then you will have some knowledge about the law. And if your approach is not in this fashion, not in this manner, again your approach is conventional, coming, attending the class, listening to the lecture, writing the exam, getting the marks cut, you are mechanical. You are stereotyped students. What a point? That doesn't help you anyway in your life. I only suggest you don't aim for numbers. Just be content with the 45, 55 to 60 now. That is required to make an application. Okay, rest of the thing, whatever the knowledge I acquired, whether I applied it or not. Application of a knowledge makes you to understand. Application of a knowledge makes you the more reason oriented, more critical oriented, more analytical oriented, more comparative oriented, more philosophical oriented. Four things always remember: historical, analytical, critical, comparative, philosophical. These are five things. If you are study anything from these five perspective, you will be a good student. If you do not study anything from these five perspective, then you will not be good. Historical, study from the background, history important. Analytical means analyze the things as it is. Critical means find out what is the deficiency in that. Comparative means what is there in the other laws. Compare this one. Then philosophical, how to cure this law, how to make this law better. What would have been this law if these points are there, if these points are not there? That is called philosophical. Okay, if you have these things in your mind, whenever you study those things by this five approach, you will be a good lawyer. What a point. This is what is required. Nothing rest of it. Nothing rest of it. Again I'm telling you, don't focus more on numbers. Don't focus getting this certificate, that certificate, this gold medal, that gold medal, and getting a photos on the dais and all those things. Forget about all those things. What happened? Be a normal person, be common person, acquire the common sense, then be critical. That is what is the. If you achieve this one, that you will be a success of this 5 years course or 3 years course. Rest of the things are secondary. Rest of the things are secondary. And that what these 5 days, this person is trying to do it. And obviously, I appreciate that fellow because he has motivated you, he has encouraged you to sit. First time I've seen that most of the people are sitting after 3 hours, 3 o'clock. Okay. Usually I see empty AV room whenever you conduct the function and all those things. And this is where you have come on your own. There is no compulsion also. Okay, you come on your own. It is voluntary participation, so definitely it is appreciable. I think whatever the effort they make it within 5 days. And one more thing I'm telling you, knowledge always pays you back. Any kind of a knowledge, it never goes waste. Waste. Someday or other day, it will pay back you, and it will give you some kind of a benefit. So knowledge is never wasted. Knowledge is never bad idea. So with these few words, now I'll hand over the mic to the some Bafna. Bafna. Okay, I'll wish him a success. Best of luck.
Thank you so much, sir. Okay, with that motivation and taking the words of Subhash sir forward on the law, I'll take you with my first slide where you can see a picture. Goddess Themis. See, this is a story of the advancement of law. Everything does not start at a high level. Okay, everything has its beginning. Like the technology, when we see 10, 20 years back, we had keypad mobiles. Now we are having touch screen mobiles with fast internet, etc. Right? So when we see how the law advanced into the society, that is this story will tell you. So once upon a time there was a king, the king's rule. Okay, that time the initial application of law was started with this notion that the king is there, and on the tongue of king there is the uh, goddess Themis. Goddess Themis, she sits on the tongue of king and she delivers the justice. She delivers the justice from the representation of king. So that was the initial notion from where the law advancement started into the society. Okay, so in the initial stage, the law was made under the impression of divinity. Divinity. It was believed that king is representing God. Then what happened? In the various cases, king gave various decisions. Okay, in the case of theft, he gave a decision. In the case of murder, he gave a decision. In the case of robbery, he gave a decisions. So various decisions which king gave, they were consolidated and practiced at the local level. Now, for every individual case of the same matter, people does not require to go to king again and find the justice. Now, among themselves, using the decisions of king, they can deliver the justice in the local level. So that was the second parallels of the advancement of law. So that was nothing but a customary practice developed into the local people by using the decisions of king as a basis for giving justice. Okay, so this was nothing but the second parallels of the advancement of the law in the society. Okay, now the third advancement happens when some people have a consolidation of the knowledge of all the decisions, of all the legal technicalities of the decisions which king used to deliver that justice. When it was in the common people, it was certain times believed that it was nothing but a bias between the people. So to remove that bias, a person who is having a higher knowledge on the aspect of law, they were given the positions at the lower level to counsel and get the decisions. Okay, so they were nothing but knowledge in the hands of some priest or some people expert in law. So that was the third stage of the advancement of law. From there, you can say the proper studying of law as a profession started. Okay, now people started to expertise the their hands on the law. From there, this expertising the law started, and it was the third stage in the parallels of advancement of law. In the fourth stage, what happened? Once some people got the expertise in the law, now there is always a certainty that when the cases of their own someone, they could do biasness, they can show biasness, or they does not, they can mold the law according to their own interest. So from there, the demand for codification started, that the law should be codified into a proper written thing, so that there can be a equality and equity in the justice. Okay, and the biasness can be removed. So from that point, we did this exercise of codification of law. So then what we did, we codified all the criminal laws, we codified the civil laws, and so on. Okay. So from that point, this was the fourth parallel of the advancement of law in the society. Okay. Then, interestingly, in a static society, the advancement of law stops at this fourth stage, that is on the stage of codification. Okay. In a static society, the advancement of law stops at this stage. Once it is codified, now people will blindly follow that codification. There will not be any fifth or sixth or seventh stage of advancement in the static society. Okay, but in a progressive society, whereas India is a progressive society, where we also adopted the sixth stage of parallels of the development and advancement of law, that was by creating legal fiction. What is this legal fiction? In certain matter, we created a notion by giving a special character to the object to be treated as a person. For example, we treat company as a person. We treated the idol of Ram as a person. Okay, so that as a legal fiction we created to just to deliver the justice. Okay, so that was nothing but a fifth stage of the advancement in the parallels of law by creating legal fiction. Okay, out there. From that legal fiction, the sixth stage, which is equity, that came from the interpretation and decisions of court. Do you know that Supreme Court of India is also called as the court of equity? To deliver the complete justice in a case, the Supreme Court can exercise their powers given under Indian Constitution under Article 141. Okay, so it is also called as court of equity, and equity means what? It is not equal distribution, it is just and fair distribution. Okay, so that was the sixth stage of advancement in the parallels of law. Okay, from equity, then we moved towards the seventh parallels of the advancement of law, that is legislation, the law making machine. Okay, in India, what do we call as legislation? Parliament plus president, right? So legislation, whenever the need comes that this law should be brought in because the society needs it, now we can bring that easily by the majority in the parliament, right? So that is nothing but a law making machine. We are having legislation, it makes the law making process easy. So that is nothing but the seventh stage of advancement of law in the society. As I mentioned you earlier, in the static society, the development of law stops at this fourth stage, and only in progressive society, the development of law moves towards its fifth, sixth, and seventh stage. So this is a introduction to the how the law has developed over to the current stage where we are using it and we are studying it. Okay. Now, coming to this subject, as we sought and as we analyzed how the law advanced into the society, now why and what makes this subject necessary? Okay, let's find its necessity from its word itself. The title of the subject is jurisprudence. It is an English word which has its Latin root in the Latin root is jurisprudentia, which means the juris means law, the prudentia means knowledge. Okay, so having the knowledge of law or having the systematic knowledge of law is the boundary of this subject, jurisprudence. In a general notion, what do you understand by the knowledge of law? In the general notion, I believe that the statutes and the judicial decisions that comes into your mind when we say the general notion, what is law? But the parallels of jurisprudence is much wider than it. It is a think tank of why, what, and how of law. It is a philosophy of law. Okay, by studying this subject, you will be able to gain a understanding that how the law works into the society, what is its nature, and how it can be interpreted. Okay, from this, a very famous line said by Harold J. Lasky. He said that jurisprudence is the eyes of law. Eyes of law. Without eye, you cannot see the world. Similarly, without jurisprudence, you cannot see the world of law. Okay. So this is nothing but to give you an understanding about the subject jurisprudence and how the law is concerned with this subject jurisprudence. I hope you understood till this point. Okay. Now, as I mentioned to you, the subject jurisprudence, what comes into this subject? So there is very interesting story about elephant and five blind men, which gives you an basis to understand this subject. In this subject, you will study different schools of law, from where you will develop the thought process of thinking about law into different type of critical way. Okay. So let me take you to that journey. So it is a story of an elephant and five blind men. The story goes like this: an elephant is placed, and five blind men were placed surrounding that elephant. They have never seen the world yet before. They were asked that, according to you, touch the elephant and say us, according to you, how does the elephant look like? Okay. One blind man was placed near his foot, one blind man was placed near his ear, one blind man near the stomach, one blind man near the tail. Everyone gave their different definition and interpretation of how the elephant looked like. According to one who was standing near his leg, according to him, the elephant looks like a pillar. According to one, the elephant looks like a wall. According to one, elephant looks like a fan. According to one, elephant looks like a snake. So different person gave different definition of how the elephant looks like. Similar thing happen in law. See, law is a universal concept. It's not just limited to India or Western or any other state or country. It is a universal concept. Okay. And in the different countries, the different ideas of law developed. Okay. So some thinkers, some jural pundits who thought into the same line that law is nothing but something which we derived from God, are placed into a one particular kind of school. Some jurists who thought the law is nothing but a result of society, they are placed into one school. Some people who thought the law is nothing but a sovereign authority makes that law and we have to follow that, they were placed into one type of school. So different thinkers who thought the law in the different senses are consolidated into this one bucket of different kinds of schools. Okay. So this is the understanding which we get from this particular example of elephant and five blind men. Okay, to understand the nature of law. Now, as I said, when we analyzed the different jural pundits who thought about law into different ways, they were placed into different type of schools. Okay, so these are the five buckets created in which we placed the different thinkers according to how their definition of law was. As I stated, the very first school which came into existence was natural school. From this school, the even before jurisprudence, this school came into existence. Okay, the birthplace of jurisprudence is Rome. The birthplace of natural school is Greece. Okay, so what was the basic philosophy of natural school? See, in the initial stage, the fiction was developed. The fiction of God was developed. Then from that fiction of God, reasoning was developed. From that reasoning, the thought process was developed. Okay. So from that, the jural thinkers, the jural pundits who thought that law is nothing but the study of nature and reason into one parallels is natural school. They all jurists who thought the study of law should be done with the consolidation with nature in it is the idea of jurisprudence. They all were placed into this natural school. Do you know, if someone threatens you on the name of God, you can actually file a case on them? There is an Indian Penal Code section for that. Anyone know which section? If someone threatens you on the name of God, how can someone threaten you on the name of God? During your exams, you can experience that, right? You do corruption with God, you give money to God, please pass me in the exam, right? So, but again, if someone threatens you on the name of God, there is IPC section 582, okay, which is applicable. You can apply that and file a case against that person. Okay, so that idea of the people who thought the nature should be taken into the center while studying law is the thought process of natural school. And all the legal pundits who thought in the similar manner, were placed in natural school, and when you study natural school, you will study about those different thinkers, whether it's Aristotle, Socrates, Plato, okay, Heracles, Sophocles, okay, all those thinkers you will study in natural school. Then comes historical school. Okay, I also marked colorful different colors in front of different schools. From that color also you can get a hint. When I'm taking yellow color, it's the light of God. Okay, sun, etc. So that is nothing but a nature coming towards the people. Okay. Then when we come to historical school, the see present is the projection of past, and future will be the presentation of present. Okay. So in the jural thinkers, the jural pundits who thought that history should be taken into study while making of law were consolidated into this particular historical school. Okay. The birthplace of the school is Germany. The founder of the school is known as Savigny. Okay. So there is a very interesting line to understand this historical school. As you can see, law is found in fashion, custom, and usage. What is fashion? What is fashion according to you? What is trending right now? See, in its early stage, any practice is just a fashion. For example, let's everyone know about Saptapadi, Sat Fere. Everyone know about that. See, let us see that how this practice could have started. In ages ago, time going back, some two people started marrying like that. The villagers saw that, oh, this is something new. We should also take it forward. They went to their own village. They started to practice that kind of practice to conduct the marriage. Okay. So when it started like that, it was fashion. When it became a practice in the people, over a period of time, it became custom. Okay. And when the count of time is forgotten, it became usage. Okay. The only difference is fashion is not law, but custom and usage is the law. According to Article 13(3)(a) of Indian Constitution, there are 8 things called termed as law, and in which custom and usage is also a law. Okay. So then comes the next school, analytical school. This school was born in England. The father is considered as John Austin. See, the Western philosophy was very much believed on there is a higher authority and there is a lower authority, superior authority, subordinate authority. So the people believed that there is a superior authority who will make the laws for their subordinate people, and they just have to follow that. And that is nothing but a positive approach towards law. Man making law for man. Okay, so that approach, which the jural pundits thought that this is the proper law to study, they all are consolidated into this particular school called as analytical school. Okay, so for historical school and for analytical school, I have given green color, which represents a definite growth in it. Okay, as we see, analytical school and historical school are still currently in picture, and they are growing day by day. Okay, in India, the sovereign authority is Parliament who makes the law, right? So, in one sense or other, the practice is still followed. Okay, the practice is still followed, and the regular growth and development is still there. So that's why green color to remember their notion. Then comes socialist school. To understand the socialist school, I want to take you to one more picture first. Can you see this chart? As I told you, first natural school came into picture, existence. Against natural school, see, there is no similarity in the concept of analytical school and historical school. Only one similarity is there between analytical school and historical school is they both started against natural school, against the concept of natural school. This only similarity they share within them. Okay, historical school and analytical school. And a modified version of historical school and analytical school is socialist school. A modified version which takes historical school also in study and analytical school also in study is socialist school. Now, what does socialist school say about it? The jural pundits who thought that laws should be such which derived from the society, which society needs, should be law. Okay. See, this is the time of World War when the atrocities of human towards human was very huge. That time, the need, some sympathy in the humans started developing, and they thought that we should do something for society. And that type of thinkers who thought that we should do something for society, we should make such laws which brings a good change in the society, they were all consolidated in the socialist school. Again, this school was born in Germany, where the uh, huge atrocities on humans have been done, Jews against Jews. Okay, so gas chambers, if you have studied, or maybe you will study human rights, then you will study this particular thing, particular incident. Okay, so then you will understand that what kind of atrocities we have committed towards our fellow species. Okay, towards the care to that we have created the socialist school. Okay, so that should result into the welfare of the society. Now here, the checklist which is followed into this particular school is law is made from taking care of society, and if it is implemented into the society and if it is not followed, then why it is not followed, the reason is investigated, and once the reason is investigated, the solution is drafted, and the solution if not works, then again this cycle continues, rectification, again law, again implement in the society, again let's see if it works or not, and then again rectification. It, the cycle continues till that point when the law is finally useful for the welfare of society. In India, what are the welfare laws we have created? Child Welfare Act, Women's Protection Act. Okay. Any other examples? Correct. So these all laws we have created because to do the welfare for the society. Okay. Then after this school comes realist school. As I stated in this diagram, historical school and analytical school, the modified version is socialist school. And the realist school is a modified version of socialist school and analytical school. Okay. It is the very new school into the picture, and the basic belief in this realist school is let us take reality into consideration. And in reality, where does the justice happens? It happens in court. Okay, they are the real application. There is the real application of law happens. So in this school, it is believed that the study of law should be done by studying the different judgments, by studying the different decisions, by studying the reality of the society. Okay, so that is the study which the thinkers of realistic school thinks. And the birthplace of the school is America, and the father of the school is considered as Oliver Wendell Holmes. Okay, so this is an overview of the schools of jurisprudence, which we gathered from the example of elephant and five blind men. Okay. Now you will going to study these schools into more detail. That session is going to be taken by Tanmay sir. Okay. So here I'll just give here to give you just an introduction to the concept to make you understand that how these schools developed over a time. Okay. So these five schools are major in the study of jurisprudence. Now, here are different principles which will give you a more idea into this subject and more idea into the philosophy of law. Okay, so the first principle is distributive justice. Distributive justice means just and fair allocation of resources. Okay, I have referred Article 38. This, first of all, taking this distributive justice, the father is considered as Aristotle. He was from natural school. Okay. Now, distributive justice concern that if there is a marginalized society, let's work by law towards them. We are not concerned with the process. We are concerned with the outcome in the distributive justice. Okay. Not distributive process. Distributive justice. Okay. You will find legal aid as a part of as a form of distributive justice. A question to you: is reservation is a form of distributive justice? Who says yes? Who says no? It is a form of affirmative action, and it is a distributive justice. Okay, so this is the first doctrine which you will find in the concept of jurisprudence and in the concept of lawmaking also, that many a times we make laws to do the justice, the distributive justice in the society. Then comes one more principle, the theory of two powers. Okay, this principle was given by Pope Glacius. There was a time, you will study in the analytical school, during analytical stage 2, there was a time when in England there is a huge dispute between state and church. Okay, church is saying that we are the owners of law. Okay, the people should come to us to get justice, and the state is saying that we are the owners of law. The people should come to us to get the justice. Then comes the Pope Gracious. He says that okay, sit down both. I'll do the mediation for you. Okay, in the matter of state, in the matter of administration, the state should have the final say. In the matter of religious things, the church should have final say, with both state not followed, with both church not followed. Okay, what happened next is the state won this war and consolidated all the powers within itself. Okay, then later, which the war was between state versus church, that war became state versus public. Now, by the time and time, we also demand our rights back from the state. Our fundamental rights is nothing but our demand from the state to give us our rights back. Okay, so that is the theory of two powers. In India, we have this separation of power. Okay, then comes doctrine of command. Then again, this doctrine was given by John Austin. He was from analytical school. As I said that the thinkers of West, they say that there is a higher authority, superior authority. They command, and their command becomes law, and the subordinate people have to follow that command. So that is the doctrine of command. That a superior authority will make a command, and that command will be the law, and the people should oblige to that command. Okay, so this is a doctrine. Then pure theory of law. Pure theory of law, if you build a pyramid, and in the structure of pyramid, on the top of that pyramid, if you see, we will place a grand norm, and that grand norm is above all the other laws of that particular state. Okay, and if any law is not in the parallels of that grand norm, that will be declared as ultra virus. Okay, that will be struck down. So this is the pure theory of law, that all the other laws should confine itself with this pure theory of law, otherwise they will be nullified. Okay, so in India, our constitution is considered as grand norm. Okay, and this principle was given by Hans Kelsen. Then comes the next doctrine, doctrine of utility. This doctrine was given by Jeremy Bentham. He said that law should be such which increases the pleasure of the society and decreases the pain of the society. That should be the objective of making of law. So that was doctrine of utility, which increases the utility of pleasure and decreases the pain. And he also gave one more theory called as dog law. He said that in reality, the judges are not concerned with making of law, but in their decision making, in the back end, chori chori chupke chupke, they make the laws. Okay, by hiding in the background of decision, they make the laws for the society. So that is nothing but the dog law according to Jeremy Bentham. And in India, we have judicial precedent treated equivalent to law. Right? When you study sources of law, you will find judicial precedent is a third source of law. Then comes comparative study of society. You remember the story of law, the advancement of law in the society? I said I refer two things, static society and progressive society. The development of law in the static society stops at fourth stage, that is codification. And the development of law continues in the progressive society till legislation. So this study and this advancement of law into the static society and progressive society was propounded by Sir Henry May. Okay, he studied the society and compared it in two bases, static society and progressive society. Okay, and he gave one principle that is called status to contract. In the initial stage, we all have a status. Okay, for example, in some time back, it was considered wife is the property of husband. But with the struck down of Indian Penal Code section 497 in the case of Joseph Shine versus Union of India, it was very much cleared by the judiciary that husband wife is not a property of husband. So hence the status to contract, we moved from the status towards the situation of contract. Okay, then reversal to that, we also have the notion of contract towards status also. Okay, we always have a debate for reservation. Okay, it is good or it is bad left on you. Okay, but it is nothing but a parallel from shifting from a state of contract towards the state of status, where we give reservation on the basis of the status of the people, whether they are OBC or scheduled caste or scheduled tribe. On the basis of that, we give them reservation. So that is the moving of society from contract towards again to the status thing. And this is given, this principle was given by Professor Allen. Then doctrine of social engineering is there. This was given by Roscoe Pound, and the basis of this principle is there is an individual interest and there is a interest of a society. By social engineering, the Roscoe Pound compared lawyer with the work of engineers. As engineers build the bridge from connecting one end to the other end, similarly, lawyers are engineers of society. They will bridge, they will build a bridge from individual interest towards the interest of society. Okay, so that is the doctrine of social engineering. Then comes principle of solidarity. Have you seen Tarak Mehta Ka Ulta Chashma? No. Okay, if you have not seen, that is a society, very good society. Okay, where different kind of species lives, people live. One, he is scientist. One, he is businessman. One, he is doctor. One, he is press reporter. Okay, so these different kind of people live, and it is a situation of society as well. And what does principle of solidarity states that every people is connected with each other into one way or other. Okay, for your all needs, you cannot depend only on yourself. If you are sick, you will go to doctor. Okay, if someone will need a legal advice, they will come to you. So likewise, the society is interconnected with each other, and this interconnection is nothing but a solidarity which society shows. Hence, this principle of solidarity. This is given by Duguid. And then there are certain other principles as well. You can have a note of them. There is a law and morality principle given by H.L.A. Hart, who specifically states that law should be kept separate, morality should be kept separate. Okay, I'll give you an example. If someone is someone don't know swim and he is drowning, you're standing there and you know how to swim, you can save that person. Are you legally obliged to go and save that person? By morally, by your own moral notion, you can take that step to go and save that person. But there is no legal obligation. If you don't save that person dies, then the family of that person or representatives cannot sue you that you was there and you did not save. Okay, so that is why HLA Hart specifically stated law should be kept separate, morality should be kept separate. Okay, there can be such laws as well, which is totally against the morality, but that is law. You have to make sure. Okay, but there in jurisprudence you will find a debate between HLA Hart and Fuller, who takes both sides. HLA Hart says that law and morality is separate, while Fuller says that morality is the basis for the law. Okay. Then there are several other principles also which plays a conceptual building note in the jurisprudence. Okay, you can have a note of them. For example, Volgist, which was given by Savagny. Volgist is nothing but coming together. Okay, the national spirit. When Modi was in rally for the election, he usually stated that if Pakistan attacks us, we will see अच्छे दिन आएंगे. Okay, so the notions which brings together the people's spirit together, that is Volgist, and out of that the law is created. Okay, then principles of punishment, reformative, deterrent theory. Okay, there are 5 principles for punishment. Okay, that was given by Salmon. So these are different principles which you will study in the jurisprudence. So with this understanding about law and jurisprudence, There are certain definitions which I want to take you through now. In the initial stage, we stated that jurisprudence is the knowledge of law. Okay, knowledge of law, knowledge of the things human and divine. It is given by Alpian. Alpian took this basis in his definition, the notion of knowledge of law. He said that the observation of things divine and human, the science of just and unjust, is jurisprudence. Okay. Then other thinkers stated that jurisprudence is a study of science, it is a study of civil law, etc. Okay. These all thinkers gave their own definition for jurisprudence according to which school they belonged, what background they had, what ideal they followed, what environment they lived in. Okay, according to which they developed their jural thought, their jural postulates. And those jural pundits you will study into the different kinds of schools. Okay, so this is some different definitions of jurisprudence. Now, lastly, as Subhash sir also stated, how this subject can be useful for you. We study this subject with many purposes are there, but some uses which I wanted to state to you specifically. One is it gives you an understanding to the principles of law, the nature of law. Once you have that understanding, you can read between the lines. Okay, the task of lawyer is not reading the line, but reading between the lines, and it is only possible when you know the nature and principle of laws. Okay, and secondly, to develop a scientific temperament in the understanding of law. Okay, with these things, the subject will find a use into your profession, and with this aim only, we have also created this masterclass sessions. In the second session, you will have a idea and note about different rights, duties, and obligation by Aditya sir. So for this class, thank you so much for attending this, and here I conclude it. Okay, thank you so much. If you have any doubt, questions, you can ask me. Is there any common email ID where I can forward this presentation if you need? Okay, in the masterclass group, I'll upload it. Okay. If you have any questions, any doubts afterward, also please feel free to approach us. This jurisprudence club is not just a name club, but you can actually approach us for any conceptual understanding of jurisprudence. Okay. Thank you again. Now you can move for your respective ends.
The bus is available for the people who are traveling by college bus. It will leave within 10 minutes, so please proceed towards it.
Ikra,
Mami, मेरा charger कहाँ है?
Ikra, lend us.
Yeah, yeah.